This is the City of Kingston's Rent Guidelines Board meeting. It is Tuesday, September 26th, 2023. The time is 6:05, and I am calling us into session. I will start by calling roll. Noah Kipley-Ogman, Chair, that's me, I'm present. Diana Lopez-Martinez.
Present.
Mia Noye.
Present.
Anthony Jr. Tampone.
Present.
Tara Perry is not here. Michael Tierney.
Here.
Carol Soto.
Present.
Present, if that didn't get all the way into your mic. Arlene Puentes.
Present.
And Michael Brown is not here. Our agenda this evening is relatively simple. We have seen distributed by email an explanatory statement and including the guideline rates of rent adjustments that we established on our June 21st, 2023 meeting. I move that the board accepts the explanatory statement and certifies the guideline rates of rent adjustments in this explanatory statement.
Second.
Hearing a second from Carol and Mie. Do we have any discussion? Hearing none, I will call a vote on the motion. Noah, aye. Diana?
Aye.
Mie?
Aye.
Junior?
Aye.
Michael?
Aye.
Carol?
Aye.
Arlene?
Yes.
The motion carries with 7 votes for and 2 absent. Mia, I understand you have a motion to bring to the board.
Yes, I would like to propose a resolution, which I have copies of that I'll pass around. I don't know how this works. Should I explain it rationale first or read the resolution first?
Why don't you read the resolution?
Okay. So this is just a resolution. Well, okay, I'll explain the rationale after. So whereas in Section 9B of the Emergency Tenant Protection Act requires the Kingston Rent Guidelines Board to adopt guidelines to assist the New York State Division of Housing and Community Renewal in establishing initial legal regulated rents for tenants in newly stabilized apartments pursuant to an individual complaint-driven process known as a fair market rent appeal. And whereas Section 6A of the ETPA provides that after the effective date of a local declaration of emergency, here, August 1st, 2022, no owner shall, quote, charge or collect any rent in excess of the initial legal regulated rent or adjusted initial legal regulated rent until such time as a different legal regulated rent shall be authorized pursuant to guidelines adopted by a rent guidelines board. And whereas on November 9th, 2022, following the review of various economic data, consideration of public testimony, and advice from representatives from the DHCR, the Kingston Rent Guidelines Board established an FMRA guideline of 16% above the rent in effect on January 1st, 2019, utilizing that date as a point of economic reference, not as a base date for enforcement purposes. And whereas the Kingston Rent Guideline Board's actions were challenged by various property owners and judicially enjoined by the Ulster County Supreme Court, and such injunctive relief rested on a finding that the FMRA guideline constituted an improper, quote, rent reduction rollback date of January 1st, 2019, end quote. And whereas the Kingston Rent Guidelines Board had not issued a final written order or explanatory statement at the time it was enjoined from implementing the agreed upon FMRA guideline and is effectively precluded from doing so now. And whereas the Kingston Rent Guidelines Board took no official action and has no jurisdiction to enforce its FMRA guideline, and expressed no opinion as a body as to the enforcement or the relief afforded under its guideline. And whereas the DHCR, not the Kingston Rent Guidelines Board, has exclusive jurisdiction to adopt and implement regulations as to the processing of FMRAs and the extent of relief afforded in connection with such applications. Now, therefore, be it resolved that the Kingston Rent Guidelines Board takes and has taken no official position as to how DHCR utilizes its FMRA guideline in the processing of FMRAs. That any judicial determination that the Kingston Rent Guidelines Board's FMRA guideline is impermissibly retroactive cannot be directed at any act or omission of the Kingston Rent Guidelines Board because no such act or omission occurred. The Kingston Rent Guidelines Board FMRA guideline base date of January 1st, 2019 was simply an economic reference point from which to measure whether rent increases had exceeded 16% since that date. The Kingston Rent Guidelines Board did not establish a look-back period which would extend or limit remedies for rent collections in excess of that guideline. So should I explain? Okay. So I wanted to propose that we vote on this resolution. As I understand it, it's really just a kind of clarifying statement of what we did, because I'm concerned about the way that our actions are being misconstrued in pending litigation. So the Ulster County Supreme Court thought, and the landlord's lawyers have argued, that we ordered a change in rents retroactively to 2019. There are two problems with that claim. First, we do not, as a board, issue any adjustments to rent. DHCR issues those adjustments. Second, our guideline uses the 2019 date as a reference point for gathering information for DHCR to use in determining FMRA appeals, not as an effective date. So the effective date is August 1st, 2022, which is when Kingston opted into the Emergency Tenant Protections Act. So I just thought that it would be appropriate, since we did not get a chance to issue an explanatory statement when we sent our 2022 guideline, for us to state clearly the limits of our jurisdiction.
Thank you for this, Mia. I have to say that I have similarly been frustrated that this board did not have the opportunity to issue a formal statement before an explanatory statement and a formal writing down of our guidelines before they were enjoined by the Supreme Court. And I think that I think you're right in naming that that means that we have not had the opportunity to be clear about the things that are being disputed in court, including about this idea that that there might be any retroactive effect. I think that you're right that there's no retroactive, that our guidelines do not have any effect on rents charged before the base date of August 1st, 2022. And I appreciate you bringing this, and I plan to vote in favor of it if we call it to a vote. Other discussion? Do we hear a second? Michael.
Second.
Other discussion?
I'd like to continue to discuss.
Yeah.
Yeah. I mean, honestly, I would like to discuss with our council this a little bit beforehand, just to make sure that we're not putting ourselves in some kind of a bind by making such a statement. I mean, I understand the political and like media need because of the misunderstandings of how this works, but my understanding is that it's the job of DHCR and now the Solicitor General to define what the legal requirements are of this, and we only have the power written into New York State law that allows us to be able to do anything. So I don't, other than making a political statement, I don't see how this could or would affect litigation, and whether or not this was guided by the impetus of this is just feelings because of like reading articles in the newspaper, or was it from feedback from legal advice?
It's not from feedback from legal advice, just my interpretation of the Ulster County Supreme Court's decision, and which, I think we discussed at the time, seems to misrepresent our actions as a board. So I think, we're kind of, as you point out, limited in what we can do, but at the very least, I think we can, clearly articulate our account of what we did, and I hope that it will at least be clarifying.
There's one line in here that kind of confused me because the statement of Guidelines Board did not establish a look-back period. It was my understanding that we did do that.
Sorry, Junior, you're referring to this last sentence?
Yeah.
The Kingston Rent Guidelines Board did not establish a look-back period which would extend or limit remedies for rent collections in excess of that guideline. I think we established a look-back period as this motion notes for economic reference, but not for enforcement purposes. Right, and I think that is some of the confusion that the court has run into. And so I appreciate this clarity that this resolution brings to saying the look-back period that the board set is for a date, utilizing that date as a point of economic reference, not a base date for enforcement purposes. I think that's in the third paragraph, at the end of the third paragraph. I think that's very, I think that's very clear.
I mean, I would be happy to make a statement like this, but I'd prefer it be reviewed by the DHCR attorneys first. I prefer that this resolution be reviewed by the DHCR attorneys before we vote on it.
Did the copies make their way?
Thank you. You do have counsel that's representing you in the appeal, and it's not us. And I know that there was a motion that was passed back in March where, Noah, you were the one who would be dealing with that counsel. So if you're going to be making a motion like this that could potentially affect the litigation, it's probably prudent to run it by that counsel first.
The counsel representing us in the pending litigation says that any resolution we pass will not be entered into the record for the case in the trial, right? So this is not, it's not going to show up in court, and that was the sum total of her advice.
If it's not for the purpose of litigation, what's the purpose?
I think for me, I think that one of the things that I like about this is that this board has not had the opportunity to say what it did in November 2022 because we didn't get a chance to write an explanatory statement, and I think that this says something, right? And it says it publicly, and it says it as the board saying it, and I think that's right. Like, even if it's not going to affect litigation, I think it's worth saying, like, we do not have the power to do any retroactive changes before the base date of August 1st, 2022. And we did not imagine the things that this board did as having any retroactive effect.
My understanding is that you've already shared that with your attorney on behalf of this board. If I'm wrong, correct me. My understanding is that you have already shared basically the basis of this information with your counsel, and it was put into whatever documents were created in defense of this board. So I would suggest, I understand everything you guys are trying to do here, but I would suggest that when the litigation is over and you get to do your certification for your 2022 guideline, that this all be incorporated in that certification to an explanatory statement as to what it was you intended to do with that guideline and the fair market rent appeal. Because right now, all the fair market rent appeals are being held in abeyance. So this will not change anything that's happening right now. So instead of muddying the waters, because while it won't go into the litigation from your point of view, it doesn't mean it won't go into the litigation from somebody else's point of view. And because there is litigation right now, I think you should let the attorneys take care of the litigation piece, and this should be part of your explanatory statement when you get to explain the fair market rent appeal and your 2022 guidelines. That would be my advice.
I don't like to overstep any counsel. I don't like to overstep counsel in any way, shape, or form, but I think that it is important to just clarify now what our intent was with that ruling. Maybe it doesn't go into court, maybe it has some bearing on something, but I would feel much better that everybody understood quite clearly, and I think that this was a very clear statement about what it is that we did. And I don't understand how that could actually hurt us.
You're saying you don't understand how it would muddy the waters.
That's,
So,
that is correct.
would you explain, counsel, how you think it would muddy the waters?
The court's already interpreted what was done. If Noah has spoke to your counsel, which I have not done, and was told that it wouldn't be included into the litigation, I'm not sure of the timing and why you would want to do this right now. Right now, you're meeting to discuss the 2023-2024 guidelines. This was not on the agenda as something that was going to be brought up. I understand under new business, you can do that, but it wasn't something that had been part of that. And if you've already shared with the attorney pretty much all the information that's in here, then I still think you should save this and use it as part of your explanatory statement for the 2022 guideline. Right now, what you're looking at is the 2023-2024 guideline, not the guideline that you passed previously.
I don't see this doing any harm, and I think we should just call the question.
I still have a question.
Does calling a question take precedence? Yes. I'm looking at Michael, who knows Robert's rules more than I do.
Yes, I don't understand what this does. Is it a press release? Is it going to be in our minutes and then we can refer to it later? Is that what we're talking about?
This board has not had an opportunity to explicitly say what we did at that November 2022 meeting. And there has been what I understand as errors of understanding of the law that the court thinks that we did things that we did not do and cannot do and that are outside of this board's jurisdiction. And I think it's valuable just to say that, right? I think it's worth it to say it because we have not had another chance to say it. And I think that I think your point, April, of save it for an explanatory statement is, I think, reasonable, but also I think that we owe it to the public whose work we're doing to be clear about the ways that what we did is being misunderstood.
I'm inclined to follow April's advice. There's a couple of things like with this that I have some concerns about. If this resolution was shared with the Solicitor General.
Sorry, to clarify, the Solicitor General has not seen this resolution. I talked with her in general about a statement.
Okay. So without the Solicitor General specifically reviewing this exact resolution, I do not think that we should be voting on it. I think it would be quite foolish for us to do so. If that information or even in the conversation about doing a resolution like this was shared with the Solicitor General, I have not been previously aware of that, and as liaison to the board from the Solicitor General, I would have it was my understanding that if that kind of conversation happened, then that would have been shared with the board. So I have some concerns about that. As far as the resolution itself is concerned, I think it's playing attorney. It's the job of the attorneys and the judges in order to say what the actual determination is and who how the law works, and I think that this last paragraph is trying to make a statement of fact that it's not the board's position to make that argument. That's the job of the attorneys to make that argument, and that's being fought out in court. So if we strike this last paragraph, then I would be fine making this resolution, saying that we don't take an official position as to how DHCR utilizes FMRA guidelines in processing FMRAs. I think that that's a perfectly acceptable statement to make. Otherwise, we're playing the job of attorney, and that's not our position to take.
Are you offering that as a friendly amendment to MIA?
Yeah, I would. I would be in favor of it if we strike the amended to strike the final paragraph.
I don't understand. The final paragraph is the resolution.
There's two paragraphs, the two lines. This, that, and this.
So that's the resolution.
Yeah, I'm
So
saying.
you're striking it.
No, this, the final. That stays. This goes away. So as I'm proposing, the resolution would say, therefore be it resolved that the Kingston Rent Guidelines Board takes and has taken no official position as to how DHCR utilizes FMRA guideline in processing of FMRAs.
I don't understand. When did we take a position?
No, he's,
The statement is saying that we don't take a position.
Right.
That's what it says here.
So it does. So I'm saying,
I'm saying I want to strike the last paragraph and make the resolution only read that.
so as a friendly amendment, how does that work? Do we discuss it or do I just accept it or not? Or
You can choose whether or not to.
to accept it? No, I think it's important to state explicitly that the 2019 date was an economic reference point, as opposed to, as opposed to an effective date. And I don't really see why that's something that we can't say, or why that's only, something that a lawyer can say. Like, I think we know what we did, and I agree with Noah that it's worth it for us to state publicly our rationale for what we did. And, because this, we know that it's not going to be, part of the pending litigation. It's not going to, be admitted in court, but this is a public process, and it has been all the way through. And so, I think part of our role as public servants is to make clear what this board is, what we do, and, our position on what we did in 2022. So I don't accept that as a friendly amendment.
Can I modify my amendment proposal?
You want to propose another friendly amendment?
Yeah.
Great.
To strike the first and last sentences of the final paragraph. So the remaining sentence would be the Kingston Rent Guideline Board FMRA guideline base date of January 1st, 2019 was simply an economic reference point from which to measure whether rent increases had exceeded 16% since that date. I think that is factual and does not venture into playing the role of attorney.
Sorry to jump the gun, Mia. I think Junior, you're being very reasonable, and think, I might think that you're right. I think you're right to name that we do not get to decide what the law says, right? That is the thing that the judges do. And I think that Mia is right to name that it's important that we reiterate that January 1st, 2019 date is a point of economic reference. And I think we do that in paragraph 3 here. And then in your latest friendly amendment, proposed friendly amendment, Junior, you're reiterating that in that last paragraph. And I think I'm convinced that it's worth being cautious about those 2 sentences that you flagged, Junior, as being sentences that are making legal claims that, like, as not a court, we should maybe steer as clear as we can from.
Especially during pending litigation.
Yeah. So I still think it's very much worthwhile to say something publicly, because I think you're right, as Mia said, this is a public process that we owe to the public, to be clear and public and transparent, and I don't think that's sacrificed by your proposed amendment, Junior, and I think that it's in fact, I think it's an improvement. But it's not my motion, so if it's a friendly amendment, Mia, you get to evaluate whether you accept the friendly amendment. If you don't, we can propose, Ray Junior, you could propose the whole thing as a separate motion.
Yeah, I think that that's okay with me, but I kind of want to hear, I guess I kind of want to hear what how other people feel about it, but I guess that's not how a friendly amendment works. So do I need to, yeah, what do other people think about that?
That sounds good to me.
I don't feel the need to change anything.
I don't either. I felt it was very clear and it protects the integrity of the ruling.
Yes, I also agree. I think it's clear and it has like the dates on 2 separate, which is what we want, right? That we didn't, that's not enforcement dates. It's just reference, like.
I'm sorry, I
example.
didn't understand.
I'm just saying that it has like the dates on 2 separate, saying that, it's not for enforcement. It's just as like for data or like for reference. Yeah.
In favor of the friendly amendment?
Yes.
It's the ball's in your court, Mia.
Okay. Yeah, I would accept that amendment.
The motion has been proposed, it's been seconded. Do we want to do any more discussion? Or should we call the question? It was a friendly amendment, so it does not need a vote on the amendment. So it's the motion as amended as amended by a friend.
Yeah, so is there discussion of the resolution as a whole?
I'll call the question. Noah, I vote aye. Deanna?
Aye.
Mie?
Aye.
Junior?
Aye.
Tara's not present. Michael?
Aye.
Carol?
Aye.
Arlene?
Aye.
And Michael Brown is not present. The motion carries. Do we have any other business?
Motion to adjourn?
Seconded. Noah, I, Deanna,
Aye.
Mie,
Aye.
Junior,
Aye.
Michael,
Aye.
Carol,
Aye.
Arlene,
Aye.
and we are adjourned. It is 6:40. If I didn't say it originally, we are in the Kingston City Hall, and this meeting is adjourned.